Next page. Chapter 28, Compromise between a company and its creditors. Synopsis. 28.1 Proposing a compromise with creditors. 28.2 Approval and sanctioning. 28.3 Compromise of tax debts. Overview. A statutory compromise under S. 155 of the Companies Act allows a company to reach a binding agreement with creditors through a majority vote, even if some creditors do not consent. Unlike common law or contractual compositions, court sanction is required to protect non-consenting creditors. Not applicable where a simple agreement between debtor and creditor is feasible, for example, if only one creditor is involved. Cases: Commissioner, South African Revenue Service v. Logical Consulting, Proprietary, Limited and Others 2019, 6, SA 472, GP. The Commissioner of the South African Revenue Services v. Cross Atlantic Properties, Proprietary, Limited 2017 JDR 1334, GP. Considered a quasi-contract where statutory mechanisms replace consensus. Includes close corporations, which can also use S72 of the Close Corporations Act. No insolvency threshold required, can be used pre-insolvency to avoid liquidation stigma. Can also be proposed during liquidation, often with the term that the liquidation order be set aside. Key features of a compromise. Flexible, directed at specific creditor classes, without following a prescribed claim ranking. Common uses: debt restructuring with financial creditors, leaving trade creditors unaffected. Terms may include extended repayment periods, reduction or discharge of claims, a haircut. Conditions: for example, approval by all creditor classes, similar compromises within a company group. Administration: a receiver typically manages funds and creditor payments. 28.1 Proposing a compromise with creditors. Eligibility and initiation. Companies not in business rescue can propose a compromise with creditors or specific creditor classes, S. 155(1). Proposal may be initiated by the Board of Directors, the liquidator if company is in liquidation, S. 155(2). Definitions and creditor classes. Arrangement, any adjustment of financial obligations. Compromise, reduction or alteration of creditor claims in exchange for certainty of payment. Affected creditors must have similar rights and interests. Case: Commissioner, South African Revenue Service v. Logical Consulting, Proprietary, Limited and Others 2019, 6, SA 472, GP. Insolvency classification: secured, preferred, concurrent, does not define creditor classes. In Logical, SARS and employees were wrongly grouped together as creditors despite different interests. Proposal requirements and notification. Proposal must be sent to creditors or relevant class along with notice of meeting, S. 155(2)(a). Filing requirement: copy must be filed with the company's commission, S. 155(2)(b). Notification methods: email, fax, or registered mail, S. 610 and Table CR3, Companies Regulations, 2011. Case: Logical, SARS was improperly notified, rendering the meeting invalid. Proposal content: must contain all information needed for creditors to decide, S. 155(3). 3 parts required. 1. Part A, background information. 2. Part B, proposed compromise terms. 3. Part C, assumptions and conditions. Financial disclosure. Projected balance sheet with key assumptions. Income and expense statement for next 3 years, S. 155(3). 4. Certification. Authorized director/officer must certify accuracy, completeness, and good faith basis of financial estimates, S. 155(5). This summary captures the legal framework and procedural aspects of corporate compromises under S. 155 of the Companies Act, with relevant case law and statutory references. Let me know if you need further elaboration or additional case law analysis. Next page. Study notes: compromise between a company and its creditors. Overview. Statutory compromise under S-155 of the Companies Act allows a company/close corporation to settle debts with an enhanced majority of creditors. Non-consenting creditors are bound but protected by court sanction, cannot be used if a simple agreement is possible, for example, only one creditor affected. Functions as a quasi-contract, replacing consensus with a statutory mechanism. Close corporations in winding up can use S-72 of the Close Corporations Act. Key features of a compromise. No threshold of insolvency or financial distress required. Classified as a pre-insolvency procedure to avoid liquidation stigma, can still be proposed during liquidation, for example, to set aside liquidation order. Flexible, can target specific creditor classes, without following insolvency rankings. Can include extended. Next page. Study notes: approval and sanctioning of a compromise. 28.2 Approval and sanctioning. Approval requirements S-155-6. Majority in number and 75% in value of creditors/class of creditors present and voting in person or by proxy. Each class of creditors must vote separately and approve the proposal. The Commissioner of the South African Revenue Services v. Cross Atlantic Properties, Proprietary, Limited 2017 JDR 1334, GP, Paris 17-23, Court Sanctioning Process. Company must apply to court after obtaining approval, S-155-7A. All creditors must be joined or at least notified. Commissioner, South African Revenue Service v. Logical Consulting, Proprietary, Limited and others 2019, 6, SA 472, GP, 479-80. Court protects dissenting or unaware creditors by considering their views. Court considerations for sanctioning, S-155-7B. Must be just and equitable. Number of creditors represented and, in liquidation cases, the master's report are considered, S-155-7, BI, 2. Full disclosure required. Material non-disclosure can lead to setting aside sanctioning. Logical case. Logical case 2019, 6, SA 472, GP, 487. Court set aside sanctioning due to non-disclosure. SARS was not properly notified. Dispute over registered mail. Unexplained financial changes. Suspected shareholder loan repayment. Employees' claims were suspect, given available company cash. Final requirements S-155-8 and 9. Court order must be filed within 5 business days and attached to the Memorandum of Incorporation, S-155-8A, B. Once filed, compromise binds all creditors/class members, S-155-8C. Surety liability remains unaffected, S-155-9. 28.3 Compromise of tax debts. Common law rule. Tax authority can only agree to compromise if it expects at least as much as in liquidation. Namex, EMS, BPK v. Commissaries van Binnenlandse Inkomst 1994, 2, SA 265, A. Logical Case 2019, 485, Cross Atlantic Properties Case, 2017, Para 27. Tax Administration Act 28 of 2011 Restrictions. Compromise prohibited if it prejudices other creditors, gives any creditor an advantage over SARS, S-203D. Applies to compromises under S-155 of the Companies Act. Chapter 14 of the Tax Administration Act. Objective: maximize net tax recovery, S-200A. Must align with tax system management and efficiency, S-200B. If company liquidates before fulfilling the compromise, SARS is no longer bound, S-205D. Next page. Study notes: approval, sanctioning, and cross-border insolvency. 28.2 Approval and sanctioning of a compromise. Approval requirements S155-6 must be approved by a majority in number, representing 75% or more in value of creditors or class of creditors present, and voting in person or by proxy. Each class of creditors must vote separately, and approve the proposal for it to bind that class. Case law. The Commissioner of the South African Revenue Services v. Cross-Atlantic Properties, Proprietary, Limited 2017 JDR 1334, GP, Paris 17-23, Court Sanctioning, S155-7. Once approved, the company must apply to court for sanctioning of the compromise. All creditors must be joined in the application or at least notified. The Commissioner of the South African Revenue Services v. Cross-Atlantic Properties, Proprietary, Limited, Supra, Para 25, Commissioner, South African Revenue Service v. Logical Consulting, Proprietary, Limited and others 2019, 6, SA 472, GP, 479-80. The court ensures protection of creditors who opposed the compromise or were unaware of it. Court's discretion to sanction, S155-7b. The court considers if the compromise is just and equitable. Factors. Number of creditors represented. In winding up cases, the master's report. Non-disclosure can lead to the order being set aside. Logical case. Issues considered. SARS was not notified via appropriate means. Unexplained financial discrepancies. Potential preferential treatment of certain creditors. Effect of court sanction, S155-8-9. Court order must be filed within 5 business days and attached to the company's Memorandum of Incorporation. Once sanctioned, the compromise binds all creditors of the relevant class from the date of filing. Sureties remain liable despite the compromise. 28.3 Compromise of tax debts. Common law principles. A tax authority may only compromise tax debts if it expects to recover at least as much as in a final liquidation. Case law. Namex, Edens, BPK v. Commissaries van Binland's Inkomst 1994, 2, SA 265, A. Commissioner, South African Revenue Service v. Logical Consulting, Proprietary, Limited and others 2019, 6, SA 472, GP, 485. The Commissioner of the South African Revenue Services v. Cross-Atlantic Properties, Proprietary, Limited 2017 JDR 1334, GP, Para 27. Statutory limitations, Tax Administration Act 28 of 2011. A compromise cannot prejudice other creditors or advantage some over others, S203d. This applies to compromises under S155 of the Companies Act. Purpose of Tax Debt Compromise, Chapter 14, Tax Administration Act. Designed to maximize net recovery, S200A. Must align with good tax system management and administrative efficiency, S200B. SARS is not bound by a compromise if the company is liquidated before meeting all conditions, S205D.
Chapter 29. Cross-border insolvency. Definition. Involves sequestration or winding up with assets or debts in different jurisdictions. Falls under insolvency law and conflict of laws, private international law. 29.2 Main problems of cross-border insolvency. Globalization of business. Increased ease of asset movement makes tracking assets difficult for trustees and liquidators. State power limitations. States can only control assets within their own borders, limiting multinational business rescue efforts. Lack of international legal instruments. Few international conventions exist to regulate cross-border insolvency. Universalist versus territorialist approach. Universalist, one global insolvency proceeding governs all assets. Territorialist, insolvency proceedings limited to local assets. Most systems blend both approaches. Equal treatment of creditors. Local laws often prioritize domestic creditors before allowing foreign representatives to take assets abroad. UNCITRAL Model Law, 1997. Provides a framework for access, recognition, and cooperation in cross-border insolvency. Not a treaty, but a guideline for countries to adopt. As of October 16, 2022, 53 states and 56 jurisdictions have adopted it. South African law. Cross-Border Insolvency Act 42 of 2000. Passed in 2000, came into effect in 2003. Ministerial designation required for application to foreign countries, S22, 5. As of 2022, no countries designated, rendering the act ineffective. Underscore. 29.3 South African Common Law on Cross-Border Insolvency. 29.3.1 Recognition of foreign insolvency representatives. Foreign insolvency statutes have no automatic effect in SA. Foreign representatives, trustees/liquidators, must seek High Court recognition. Case law. R.V. Etberg 1932 AD 142-145. Cooperative Moratorium Cementisti and Others v. Companies and Intellectual Property Commission and Others 2021, 3, SA 393, SCA, 401-2. Mount Pretty Scene, Galsworthy Limited v. Pretty Scene Shipping SA and Another 2021, 5, SA 134, SCA, 165. 29.3.2 Division by property and person type. Key distinction. Movable property versus immovable property, natural persons versus juristic persons, companies/corporations. Determines whether a foreign representative can deal with South African assets. Underscore. Summary. Compromises require 75% creditor approval and court sanction. Court protects minority creditors and reviews fairness before sanctioning. Tax debts cannot be compromised if prejudicial to other creditors. Cross-border insolvency faces challenges due to jurisdictional conflicts. South African common law requires high court recognition of foreign insolvency representatives. The Cross-Border Insolvency Act, 2000, remains ineffective due to lack of designated countries. Next page. Here's a structured summary of the provided text on cross-border insolvency. Underscore. Chapter 29, Cross-Border Insolvency. 29.1 Definition of cross-border insolvency. Occurs when a sequestration or winding up involves property or debts in a jurisdiction other than where the court order is granted. Involves insolvency law and private international law, conflict of laws. 29.2 Main problems of cross-border insolvency. Globalization of business. Debtors use technology to shift assets internationally, making it difficult for trustees and liquidators to track funds. State power limitations. A state can only deal with a debtor's assets within its territory, limiting multinational business rescues. Lack of international instruments. Few treaties address cross-border insolvency comprehensively. Universalist versus territorialist approaches. Universalist. All debtors' assets handled in a single proceeding. Territorialist, insolvency proceedings are limited to each country's jurisdiction. Most legal systems adopt a blend of both. Equal treatment of creditors. In principle, creditors should be treated equally. However, many jurisdictions prioritize local creditors over foreign representatives. No universal convention. The UNCITRAL Model Law on Cross-Border Insolvency, 1997, serves as a non-binding framework adopted by 53 states. As of 2022, South African law. Primarily based on common law. Cross-Border Insolvency Act 42 of 2000 adopted but not yet enforced due to the lack of a ministerial designation of applicable foreign countries. 29.3 South African Common Law of Cross-Border Insolvency. 29.3.1 Foreign insolvency statutes not applicable, recognition of foreign representatives required. Foreign insolvency laws have no effect in South Africa. Foreign representatives must apply to the High Court for recognition before dealing with local assets. Case law. R.V. Etberg 1932 AD 142. Cooperative Moratorium Cementisti v. SIP 2021, 3, SA 393, SCA, 401-2. Mount Pretty Scene, Galsworthy Limited v. Pretty Scene Shipping SA 2021, 5, SA 134. SCA, 165. 29.3.2 Division by property type and persons type. Foreign representatives' authority to deal with South African assets depends on property type, movable versus immovable property, debtor type, natural persons versus juristic persons. 29.3.3 Movable property and natural persons. Movable property follows the law of the debtor's domicile. Lex domicilii. If a natural person is declared insolvent in their domicile country, their movable property worldwide vests in the foreign trustee. Despite this principle, recognition by South African courts is still required before dealing with local assets. Case law. The Unviventer No 1981, 2, SA 152, W, 155. Ex parte Palmer No, in Rehan 1993, 3, SA 359, C, 362. Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 155-6. Constitutional right of South African creditors. Section 34 of the Constitution protects access to courts. The principle of no self-help, Chief Lesotho v Northwest Agricultural Bank 2000, 1, SA 409, CC, prevents foreign representatives from acting unilaterally. Recognition ensures fair notice to local creditors. Foreign representatives must apply to the High Court before collecting or selling assets in South Africa. 29.3.4 Debtors that are juristic persons. A foreign representative, not the company itself, must apply for recognition before dealing with assets. Case law. Ward v. Smith, Enrique v. Zambia Airways Corporation Limited 1998, 3, SA 175, SCA, La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 167. Cooperativa v. SIP 2021, 3, SA 393, SCA, 401-2. Requirements for recognition. The representative must be appointed where the company is registered or has its principal place of business. Recognition does not automatically validate claims but allows further proceedings in South Africa. This summary covers sections 29.1 to 29.3.4 of the chapter. Let me know if you'd like additional details or further sections summarized. Next. Page 29.3.3 Movable Property and Natural Persons. Lex domicilii principle. Movable property is governed by the law of the debtor's domicile. Automatic vesting. A natural person declared insolvent in their domicile is automatically divested of their movable assets globally, including in South Africa. The Unviventer No 1981, 2, SA 152, W, 155. Foreign Representatives Authority. In theory, the foreign trustee may deal with the vested property freely. In practice, recognition from South African courts is required before managing local assets. Ex parte Palmer No, in Rehan 1993, 3, SA 359, C, 362, Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 155-6. Constitutional implications. The rule of practice requiring court recognition has been elevated to a constitutional requirement. Case, Cooperativa Moratorium Cementisti v. SIPC. The Italian company applied instead of its representatives, which was improper. Cooperativa, Supra, 402. The Supreme Court of Appeal rejected the request as it violated the constitutional right of South African creditors to access courts. S34 of the Constitution. A foreign composition order cannot be imposed on local creditors without due process. Chief Lesotho v Northwest Agricultural Bank 2000, 1, SA 409, CC, confirms that self-help is unconstitutional. Section 34 of the Constitution protects creditors independently of the foreign representative. Section 2 of the Constitution establishes that any law or conduct inconsistent with the Constitution is invalid. Recognition by the High Court is mandatory. A foreign representative cannot unilaterally enforce claims over South African assets. He must apply for recognition and further court directions to notify local creditors. The Constitution governs all legal actions in South Africa, ensuring fair creditor treatment. 29.3.4 The debtor that is a juristic person. Mandatory recognition by the High Court. A representative dealing with the insolvency of a juristic person must always seek recognition. Relevant case law. Ward v. Smith, Enrique v. Zambia Airways Corporation Limited 1998, 3, SA 175, SCA, La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 167. Cooperativa, Supra, 401-2. Application must be made by the foreign representative, not the company itself. Cooperativa, IDEM, 402. Requirements for recognition. Representative must be appointed in the country where the company is registered or has its principal place of business. La Monica v. Baltic Reefers Management Limited, Supra, 169. Must prove genuine appointment. Validity of claims is determined in later proceedings, not during recognition. Let me know if you need any refinements. Next page. Study notes on cross-border insolvency, recognition and protection of creditors. 29.3.3 Movable property and natural persons. Lex domicilii applies to movable property, governed by the debtor's domicile. Insolvency declaration in domicile court automatically divests debtor of movables worldwide. South African case law. Viljoen v. Venterno 1981, 2, SA 152, W, 155, foreign insolvency recognized in SA. Ex parte Pomerno, in Rehan 1993, 3, SA 359, C, 362, Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 155-6, foreign representatives need recognition before dealing with SA assets. Recognition rule now considered a constitutional requirement. Cooperativa case, Italian company failed to use correct representatives. Wallace Ja, imposing foreign insolvency terms on SA creditors without legal process violates S34 of the Constitution, right to court access. Constitution prohibits self-help. Chief Lesipo v. Northwest Agricultural Bank 2000, 1, SA 409, CC. Implications. Foreign representatives must seek high court recognition. SA creditors' rights, including court access, must be upheld. Foreign trustees cannot act independently in SA without court approval. 29.3.4 Juristic persons and recognition. Foreign representatives must apply to the High Court for recognition. Key cases. Ward v. Smith, Enrique v. Zambia Airways Corporation Limited 1998, 3, SA 175, SCA, recognition necessary. La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 167, representative must apply, not the company. Cooperativa, Supra, 401-2, representatives must act where company is registered. Representative must prove genuine claim. Apply for recognition before initiating legal proceedings in SA. 29.3.5 Immovable property, recognition always required. Lex Situs governs immovable property. Law of the property's location. Foreign representatives must always apply to the SA High Court. Case law. Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 156, immovable property remains vested in debtor. Applies to both natural persons and juristic persons. Ex parte BZ Stegman 1902 TS 4047-8, Moolman v. Builders and Developers 1990, 1. SA 954, A, 960, SA courts require recognition before foreign representatives can manage immovable assets. 29.3.6 Protection of South African creditors. Recognition principles, comity, convenience, equity. Ward v. Smith, La Monica v. Baltic Reefers, SA courts recognize foreign insolvency based on fairness. Society of Lloyds v. Roman 2006, 4, SA 23, C. 64, comity not applied if against public policy. South African creditors' rights. Foreign sequestration does not prevent SA creditors from suing in SA. Hassan v. Barange No 2012, 6, SA 329, SCA, 337-8. Asset realization conditions, local creditors paid before funds transferred abroad. Cooperativa, Supra, 402. Legislative support. Moolman v. Builders and Developers, Proprietary, Limited, 1990, 961-2, recognized representatives can use SA law for asset recovery, for example, Companies Act 61 of 1973. 29.3.7 Concurrent insolvency proceedings in different countries. External company winding up in SA is controversial. Discussed in Chapter 23. Saxty Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA, 357, an external company is not a separate legal persona. Key principles. Dual proceedings can occur, Separate winding up in different countries. Local liquidators act independently. South African liquidator can handle SA assets/liabilities. Foreign winding up does not automatically affect SA proceedings. Legal implications. Manitoba Investment Holdings Limited v. Lipchin 2010, 2, SA 612, GNP, 620. Deregistration in SA does not erase legal personality. SA liquidators can act under S. 391 of the Companies Act 1973. Recover assets globally. Seek foreign court recognition for asset recovery. 29.3.8 Principle of demarcation in cross-border insolvency. Need for a demarcation principle. Saxtino v. Proudfoot SA, Proprietary, Limited, Supra, 359-60. Liquidators may impeach transactions only if insolvency proven. Parent company rescued in Namibia. SA creditors not automatically bound by foreign compromise. Supreme Court of Appeal, SCA, ruling. Dismissed case based on lack of evidence under S. 341 of the Companies Act 1973. SA liquidators need to prove insolvency before voiding transactions. Summary of key legal provisions. Constitution of SA, 1996. Section 34, Right of Access to Courts, prevents self-help. Section 2, Constitution is supreme, inconsistent law is invalid. Companies Act 61 of 1973. Section 391, SA liquidators can seek foreign recognition. Section 341, Proof of insolvency needed for voidable transactions. Companies Act 71 of 2008. Schedule 5, Item 9. Transitional provisions still apply older laws. Insolvency Act. Sections 29(1), 30, Requirements for impeaching voidable transactions. Key takeaways. Recognition of foreign insolvency. Movables, recognition required due to constitutional concerns. Immovables, always requires high court recognition. Juristic persons, representatives must apply for recognition. South African creditors are protected. Cannot be automatically bound by foreign insolvency orders. Local creditors must be paid before assets are sent abroad. Concurrent proceedings create legal conflicts. A single company remains one legal entity despite dual registration. Liquidators must work under separate legal estates per country. Principle of demarcation is needed to avoid conflicts between jurisdictions. These notes provide a detailed yet concise summary of cross-border insolvency rules in South Africa, focusing on recognition, protection of creditors, and legal conflicts in dual proceedings. Next. Try again. Page 29.3.5 Immovable property, recognition always required. Lex situs principle, immovable property is governed by the law of its location. Debtor's ownership, property remains vested in the debtor despite foreign insolvency. Lagoon Beach Hotel, Proprietary, Limited v. Lahaino 2016, 3, SA 143. SCA, 156. High Court recognition. Foreign insolvency representatives must apply for recognition in the South African High Court before dealing with South African immovable property. No distinction between debtor types. Recognition applies regardless of whether the debtor is a natural or juristic person. Ex parte BZ Stegman 1902 TS 4047-8. Mulman v. Builders and Developers, Proprietary, Limited, in provisional liquidation, used to intervening 1990. 1, SA 954, A, 960, Lagoon Beach Hotel, Proprietary, Limited v. Lahaino, Supra, 155-6. 29.3.6 Guiding Principles and Protection of Local Creditors. Recognition discretion, courts apply comity, convenience, and equity when deciding on recognition of a foreign representative. Warden and other v. Smith and others. Enrique v. Zambia Airways Corporation Limited 1998. 3, SA 175, SCA, 179, La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 168. Public policy exception, comity is not applied if it conflicts with public policy. Society of Lloyds v. Roman 2006, 4, SA 23, C, 64. Local creditor actions. South African creditors can still bring actions in SA courts despite a foreign sequestration order. Hassan and another v. Bahrain No 2012, 6, SA 329, SCA, 337-8. Priority to local creditors. South African courts impose conditions on foreign representatives, ensuring local creditors' claims are settled before assets are removed to a foreign jurisdiction. Cooperativa, Supra, 402. Legal basis for recognition. Recognition allows reliance on South African law, including interrogation provisions under the Companies Act 61 of 1973, Moolman v. Builders and Developers, Proprietary, Limited, in provisional liquidation, used to intervening, Supra. 29.3.7 Concurrent proceedings in different jurisdictions. Winding up external companies. Debate exists on whether an external company can be wound up in SA, see Chapter 23. If permissible, an external company in SA can be wound up separately from its foreign counterpart. Saxty Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA, 357. Discontinuation of foreign proceedings does not affect the SA winding up process. Conflict of authority. A company registered in two jurisdictions remains a single legal persona. Dual registration can cause conflicts between simultaneous liquidations. Saxty Novi Proudfoot SA, Proprietary, Limited, Supra, 357. A principle of demarcation is needed to resolve disputes between liquidators. Legal effects of deregistration. An external company retains its separate persona even after deregistration in SA. Manitoba Investment Holdings Limited v. Lipchin and others 2010, 2, SA 612, GNP, 620. 29.3.8 Liquidators' powers across jurisdictions. Section 391 of the Companies Act 61 of 1973. South African liquidators can challenge voidable transactions regardless of where the assets are located. If assets are outside SA, the liquidator must seek recognition of the South African court order in that foreign jurisdiction. Case law interpretation. In Saxty Novi Proudfoot SA, Proprietary, Limited, 2006, 6, SA 358, SCA, 360-1, the court based its decision on the interpretation of S. 341 of the 1973 Companies Act rather than cross-border insolvency principles. The South African liquidator failed to prove the debtor company was insolvent at the time of his action. The court amended the ruling to absolution from the instance, i.e., dismissal due to insufficient evidence. Need for demarcation principle. Companies with dual registration should have separate estates in different jurisdictions. A principle of demarcation should be developed to clarify liquidators' authority when disputes arise in cross-border insolvency cases. Next page. 29.1 Definition of cross-border insolvency. Cross-border insolvency involves sequestration or winding up proceedings concerning property or debts located in a jurisdiction other than where the court order is granted. It intersects with conflict of laws. Private international law. 29.2 Main problems of cross-border insolvency. Globalization of business, assets and currency can be transferred rapidly, making it difficult for trustees and liquidators to track them. State power limitations. Each state can only manage the debtor's assets within its territory, creating challenges in business rescue efforts. Lack of international instruments. Few treaties or conventions exist to regulate cross-border insolvency comprehensively. Universalist versus territorialist approach. Universalist, all debtors' assets are dealt with in one proceeding, recognized worldwide. Territorialist, each country manages only the debtor's assets within its borders. Most legal systems adopt a mix of both approaches. Equal treatment of creditors. Creditors in the same class should be treated equally, including foreign creditors. However, many countries prioritize local creditors before allowing assets to be removed from their jurisdiction. Uncitral Model Law on Cross-Border Insolvency, 1997. Proposes solutions for access by foreign representatives and creditors, recognition of proceedings, and court cooperation. Not a treaty, but a template for states to adopt. By 2022, 53 states in 56 jurisdictions had adopted it. South Africa's position. Governed by common law principles. The Cross-Border Insolvency Act 42 of 2000, based on the UNCITRAL model law, has been ineffective because no foreign countries have been designated for its application. 29.3 South African Common Law of Cross-Border Insolvency. 29.3.1 Foreign insolvency statutes not applicable, recognition of foreign representatives required. Foreign insolvency laws have no effect in South Africa. R. V. Etberg 1932 AD 142-145, Cooperativa Moratori and Cementisti and others v. Companies and Intellectual Property Commission and others 2021, 3, SA 393, SCA, 401-2. Foreign representatives, for example, trustees, liquidators, must apply for recognition in the South African High Court before acting on local assets. Pretty Seen, Galsworthy Limited v. Pretty Seen Shipping SA and another 2021, 5, SA 134, SCA, 165. 29.3.2 Division by property and person type. Movable versus immovable property determines whether a foreign representative can deal with South African assets. Natural versus juristic persons. Different rules apply depending on whether the debtor is an individual or a company. 29.3.3 Movable property and natural persons. Movable property, for example, cash, securities, is governed by the law of the debtor's domicile, lex domicilii. A foreign insolvency order may be recognized automatically for movable property, but recognition is still required for enforcement. 29.3.4 Juristic persons, companies. The lex domicilii approach does not apply to corporate entities. Foreign companies must seek high court recognition before South African assets can be included in foreign insolvency proceedings. 29.3.5 Immovable property, recognition always required. Governed by lex situs, law of the property's location. Even if a foreign insolvency order is recognized, the debtor retains ownership until South African courts confirm otherwise. Lagoon Beach Hotel, Proprietary, Limited v. Lahane No 2016, 3, SA 143, SCA, 156. Recognition applies regardless of whether the debtor is an individual or a company. Ex parte BZ Stegman 1902 TS 4047-8. 29.3.6 Guiding principles and protection of local creditors. Recognition of foreign orders is discretionary. Courts consider comity, convenience, and equity. Ward v. Smith 1998, 3, SA 175, SCA, 179. Public policy exceptions apply. Society of Lloyds v. Roman 2006, 4, SA 23, c. 64. Local creditors' rights. Local creditors may still sue the debtor in SA despite a foreign sequestration. Hassan v. Barange No 2012, 6, SA 329, SCA, 337-8. Foreign representatives must prioritize South African creditors before repatriating assets. Cooperativa, Supra, 402. Legal basis for recognition, allows foreign representatives to use South African law for interrogation and asset recovery. Companies Act 61 of 1973. 29.3.7 Concurrent proceedings in different jurisdictions. Debate over external company winding up. Some argue SA courts can wind up an external company separately from foreign proceedings. Saxton Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA, 357. Even if foreign proceedings cease, the SA liquidation may continue. Conflict of authority and dual registration. A company registered in multiple jurisdictions remains a single legal entity. If liquidations occur in different countries, disputes may arise over which jurisdiction has priority. 29.3.8 Effect of foreign sequestration on contracts. Foreign sequestration does not automatically terminate contracts in SA. Local contract laws determine whether a foreign insolvency order affects contractual obligations. 29.3.9 Effect of South African rehabilitation on foreign debts. Rehabilitation in SA does not discharge foreign debts unless foreign courts recognize it. Foreign creditors may still enforce claims in their jurisdictions. March 29, 2010 South African representative recovering foreign assets. A South African liquidator must apply for recognition in the foreign jurisdiction before collecting or distributing assets. March 29, 2011 Conclusion to Common Law and Introduction to Cross-Border Insolvency Act. The common law remains the primary framework due to the inactivity of the Cross-Border Insolvency Act 42 of 2000. The act was based on the ancestral model law, but it has not been implemented due to a lack of ministerial designation of applicable foreign countries. 29.4 Cross-Border Insolvency Act 42 of 2000. 29.4.1 Preamble, Application and Objectives. Based on ancestral model law, aims to facilitate cooperation between SA courts and foreign jurisdictions. 29.4.2 Application of the Act. Limited by S22, 5, can only apply to foreign countries designated by the Minister of Justice. No countries have been designated, making the Act ineffective. 29.4.3 to April 29, 2011 Key provisions. Recognition of foreign representatives and proceedings requires High Court approval. Distinction between foreign main and non-main proceedings. Main proceedings, where the debtor has its center of main interests, COMI. Non-main proceedings, jurisdictions where the debtor has significant business activities. Urgent provisional relief. Temporary orders can be granted before full recognition. Cooperation between courts encourages communication between SA and foreign courts. Presumption of insolvency and hodgepodge rule. Recognized foreign proceedings create a presumption of insolvency in SA. Hodgepodge rule prevents creditors from recovering more than what they would receive if all proceedings were consolidated. 29.5 Conclusion. SA's cross-border insolvency law is largely common law-based. The Cross-Border Insolvency Act remains inactive due to ministerial inaction. Legal reforms are needed to align SA law with international insolvency standards. Next page. 29.3.3 Movable property and natural persons. Movable property governed by Lex Domicilii, law of the debtor's domicile. Automatic vesting. When a debtor is declared insolvent in their home country, their movables worldwide, including in SA, theoretically vest in the foreign trustee, the Une Vivente No 1981, 2, SA 152, W. 155. Recognition still required. Though automatic vesting applies in theory, foreign trustees should seek High Court recognition before dealing with local assets. Ex parte Palmer No, in Reha 1993, 3, SA 359, C. 362, Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 155-6. This rule has evolved into a constitutional requirement binding on foreign representatives. Cooperativa Moratória and Cementisti v. Companies and Intellectual Property Commission 2021, 3, SA 393, SCA, 402. The right of access to courts, S34, Constitution of SA, 1996, prevents imposition of foreign insolvency terms without notifying local creditors. Chief Lesipo v. Northwest Agricultural Bank 2000, 1. SA 409, CC. Foreign representatives must apply to the High Court for recognition. Must not act unilaterally in SA without judicial oversight. Recognition process ensures local creditors' constitutional rights are upheld. 29.3.4 The debtor that is a juristic person. Foreign representatives of companies must always seek High Court recognition before dealing with local assets. Ward v. Smith 1998, 3, SA 175, SCA, La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 167, Cooperativa 401-2. Company itself cannot apply, only the appointed foreign representative can. Cooperativa 402. Recognition criteria. Representative must prove appointment where the company is registered or has its principal place of business. La Monica v. Baltic Reefers Management Limited 169. Claims validity is not determined at the recognition stage but in subsequent proceedings. 29.3.5 Immovable property, recognition always required. Governed by Lex Situs, law of the property's location. Immovable property does not vest automatically in a foreign representative. Foreign representatives must always apply for High Court recognition before managing immovable property in SA. Lagoon Beach Hotel, Proprietary, Limited Villa Hang No 2016, 3, SA 143, SCA, 156. No distinction between natural persons and juristic persons, same recognition requirement applies. Ex parte BZ Stegman 1902 TS 4047-8, Mulman v. Builders and Developers, Proprietary, Limited 1990, 1, SA 954, A, 960. 29.3.6 Guiding Principles and Protection of South African Creditors. Recognition is discretionary, based on comity, mutual legal respect, convenience, practical benefits, equity, fairness. Ward v. Smith 1998, 3, SA 175, SCA, 179, La Monica v. Baltic Reefers Management Limited 2011, 3, SA 164, WCC, 168. Public policy limits comity, If foreign insolvency conflicts with public interest, recognition may be denied. Society of Lloyds v. Roman 2006, 4, SA 23, c. 64. Foreign sequestration does not prevent local creditors from suing the debtor in S.A. Hassan v. Bahrain No. 2012, 6, SA 329, SCA 337-8. Asset realization conditions. South African courts can impose conditions ensuring local creditors are paid before assets are repatriated. Cooperativa 402. Case precedents. Ex parte Stein 1979, 2, SA 309, 0, 311-12. Natural persons. Muhlman v. Builders and Developers, Proprietary, Limited 1990, 1, SA 954, A, 961-2, 957-8. Juristic persons. Recognition allows foreign representatives to rely on SA domestic clause. Example, Companies Act 61 of 1973 provisions for commissions and interrogations, Muhlman v. Builders and Developers, Proprietary, Limited 1990, 1, SA 954, A. Next page. Study notes, cross-border winding up and contractual effects of foreign sequestration. _ 29.3.7 Separate proceedings in different countries involving the same debtor. Debate on external company winding up in South Africa. Controversial whether an external company can be wound up in SA. See Chapter 23 Introduction and 23.2.2v. Assuming winding up is possible, an external company in SA may be wound up independently of its foreign counterpart. Case law, Saxton Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA 357. External company may be subject to simultaneous winding up processes. Foreign winding up proceedings do not affect the SA process. Respective liquidators deal independently with assets and liabilities in each country. Legal personality and conflict resolution. Supreme Court of Appeal, SCA, in Proudfoot's case. External company registration does not create two separate legal personae. A single legal persona exists, registered in two jurisdictions. Potential for conflict between simultaneous liquidators, a demarcation principle is needed. Effect of deregistration. External company retains legal personality post-deregistration in SA, Manitoba Investment Holdings Limited v. Lipchin and others 2010, 2, SA 612, GNP. 620. Liquidators' powers and cross-border recovery. Section 391 of Companies Act 1973, read with SCH 5, Item 9 of Companies Act 71 of 2008. Allows SA liquidator to impeach voidable transactions in SA, regardless of asset location. If assets are outside SA, foreign court recognition of the SA order is required. Case law, Saxton Novi Proudfoot SA, Proprietary, Limited 2005 Joel 14088, W. Company remains a single entity despite separate winding up proceedings. Each jurisdiction manages its own estate, assets, and liabilities. Private international law principle. A company's status is determined by the law of its incorporation. Conflict between parent and external company liquidation. Section 340 of the Companies Act 1973 and Insolvency Act governs companies unable to pay debts at the time of impeachment proceedings. Namibian parent company entered a compromise that bound all Namibian creditors. SA external company remained in liquidation. SA liquidators' action to impeach payments failed as the parent company was no longer insolvent. Final decision in Supreme Court of Appeal, SCA. Saxton Novi Proudfoot SA, Proprietary, Limited 2006, 6, SA 358, SCA. Action failed due to timing. Compromise was sanctioned before liquidation action. Liquidator did not prove insolvency at the institution of action. Court amended order to absolution from the instance, dismissed claim due to insufficient evidence. Need for a principle of demarcation in cross-border insolvency. External company remains a single entity but has separate estates in different jurisdictions. A principle is needed to resolve disputes between liquidators. _ 29.3.8 Effect of foreign sequestration and discharge on contracts. Proper law of the contract. Law governing contract validity and discharge is determined by the proper law chosen by the parties. Smith and Borain, 2021, 54-3 Silsa 1. Case law. Standard Bank of SA Limited v. Freuchen and Newman 1924 8171. Ex parte Spinaz and another NNO 1985, 3, SA 650, A. Contract discharge via sequestration is determined by the proper law. 2 rules governing sequestration's effect on contractual debt. 1. Primary rule, Hope Rule. If insolvency law the governing contract's country discharges the debt, SA law recognizes it, in re Percy Hope, 1885-1888, 2 SARTS 25. Example, English bankruptcy order on an English law contract is valid in SA. 2. Secondary rule, Gibbs Rule. If discharge occurs under foreign law, other than the contract's governing law, SA does not recognize it. Anthony Gibbs and Sons v. Société Industrielle et Commerciale des Métaux, 1890, 25 QBD 399. Example, French bankruptcy discharge on an English contract not recognized in England. Application to pre-insolvency/winding up proceedings. Position under SA conflict of laws is unclear. Foreign restructuring, for example, U.S. Chapter 11, UK administration, not applicable to external companies in SA. External companies do not qualify for SA Business Rescue, Chapter 6, Companies Act 71 of 2008, Cooperativa 394-7. General Rule. Pre-insolvency restructuring follows the proper law of the contract. If Freuchen and Newman, SA follows English law precedents, OJSC International Bank of Azerbaijan, 2019, 2 All ER 713. Debate, Gibbs Rule versus No Gibbs Approach. Gibbs Approach. SA creditors under SA law can rely on Gibbs/Ferguson to reject foreign restructuring. No Gibbs Approach, concursus creditorum argument. Argues for overriding contract law principles in favor of collective creditor interests. Issue, no insolvency order exists yet, so no concursus creditorum applies. Walker v. Seifert No 1911 AD 141 166. Applying insolvency rules without sequestration is legally questionable. Need for judicial or legislative resolution. Senior SA courts must decide between Gibbs Rule or No Gibbs Approach. Legislature has excluded business rescue and compromise for external companies. Companies Act 71 of 2008. Uncertain when reform will occur. Alternative solutions. Common law compromise with creditors. Difficult in practice as it requires unanimous creditor consent. Risk of winding up or asset execution if creditors do not accept a compromise. Key takeaways. External companies may face dual liquidation proceedings in different countries. SA liquidators operate independently, but a principle of demarcation is needed to resolve conflicts. Contractual debt discharge follows the proper law of the contract. Primary rule, Hope. Discharge recognized if issued by the contract's governing law. Secondary rule, Gibbs/Ferguson, foreign discharges are not recognized. SA courts must decide between Gibbs and No Gibbs approach for pre-insolvency restructurings. External companies cannot undergo SA business rescue, creating an urgent legal gap. Next page. Study notes, cross-border insolvency in South Africa. 29.3.9 The effect of a South African rehabilitation on foreign debts. A debtor's rehabilitation in South Africa discharges foreign debts. Case law, North American Bank Limited, in liquidation, v. Granite 1998, 3, SA 557, W. March 29, 2010 South African insolvency representative investigating foreign assets. A trustee or liquidator may apply to the South African High Court for letters of request to investigate and recover assets abroad. No prima facie case or reasonable prospect of success required, only a genuine belief that foreign proceedings should be initiated. Case law. Gardner and another v. Walters in another NNO, 2002, 5, SA 796, c. 810-11, no need for impeccable information. Mere hearsay may suffice. Ex parte Vessels Inventor NNO, in re Pike Knott's Insolvent Estate, 1996, 2, SA 677, 0, 681, contradicts Gardner by requiring more certainty. The representative, once recognized in a foreign jurisdiction, may apply to foreign courts for recognition. Work with civil servants, banks, and other institutions to locate and recover assets. Return proceeds to South Africa for distribution among creditors. March 29, 2011 Introduction to the Cross-Border Insolvency Act. The Cross-Border Insolvency Act differs from common law by Eliminating distinctions between movable and immovable property, applying equally to natural persons and juristic persons. Introducing foreign main proceedings versus foreign non-main proceedings distinctions. Underscore. 29.4 Cross-Border Insolvency Act. 29.4.1 Preamble, Application and Objectives. Chapters cover interpretation and principles, foreign representatives' access to SA courts, recognition of foreign proceedings, cooperation between courts, concurrent insolvency proceedings, objectives. Facilitates international cooperation in insolvency matters, enhances legal certainty for trade and investment, protects creditors, the debtor, and maximizes asset value, supports business rescue to safeguard investments and jobs. 29.4.2 Application of the Act. Applies when foreign courts request assistance in South Africa. South African courts request assistance abroad. Concurrent insolvency proceedings exist in SA in another country. Foreign creditors want to initiate or participate in South African insolvency. South African deviation from UNCITRAL model law. Limited to designated states chosen by the Minister of Justice by notice in the Government Gazette. Minister must ensure reciprocity before designating a country. Withdrawal of designation does not affect pending proceedings. Priority of international treaties. The Act yields to conflicting international agreements. S3. Recognition of foreign proceedings. The High Court is responsible. S4. South African insolvency representatives, trustees, liquidators, may act in foreign states. S5. Public policy limitation. Courts may refuse recognition if it conflicts with South African public policy. S6. Uniform international interpretation required. S8. 29.4.3 Access of foreign representatives and creditors to SA courts. Foreign representatives can apply directly to SA courts. S9. Do not automatically submit themselves to SA jurisdiction. S10. May initiate SA insolvency proceedings if conditions are met. S11. Can participate in ongoing SA proceedings. S12. Foreign creditors have equal rights to South African creditors. Same ranking system applies. Foreign claims cannot rank lower than non-prefer local claims. S13. Must be notified like local creditors. S14. 29.4.4 Recognition requirements for foreign representatives. A foreign representative must apply to the High Court for recognition. Required documents. Proof of appointment. List of all related foreign proceedings. S15. Presumption of main interests. Debtor's registered office or habitual residence is presumed to be its center of main interests. S16.3. 29.4.5 Distinction between foreign main and non-main proceedings. Foreign main proceedings occur in the state where the debtor has its center of main interests. Foreign non-main proceedings occur in a state where the debtor has an establishment. Definition: any place where the debtor carries out economic activities with human resources and assets. S1C. 29.4.6 Urgent relief before recognition decision. Pending recognition, the High Court may grant urgent relief. S19.1, such as stay of execution, asset preservation measures, suspension of debtor's disposal rights, witness examination, collection of evidence. Court may refuse relief if it interferes with foreign main proceedings. S19.4. 29.4.7 Effect of recognizing foreign main proceedings. Recognition automatically stays individual actions against the debtor, stays execution on assets, suspends the debtor's disposal rights. S21. Stays are subject to South African Insolvency Act, S22, and Companies Act, S341, S359 of 1973 Act. Creditors may still preserve claims, request SA insolvency proceedings, file claims in ongoing SA insolvency proceedings. S23. 4. Effect on South African assets, recognized as if the debtor had been sequestrated in South Africa. S21D. 29.4.8 Additional relief for foreign proceedings. Relief under S21 may include staying proceedings and execution, suspending debtors' disposal rights, appointing an administrator for debtors' assets, allowing evidence collection, permitting asset distribution, ensuring SA creditors are protected. If relief concerns non-main proceedings, it must involve relevant assets or needed information. S21.3. Court must protect creditors and the debtor when granting relief. S22. 29.4.9 Cooperation between South African and foreign courts. Courts must cooperate with foreign courts/representatives. S25.1. Methods of cooperation. S27. Communication between courts. Coordination of proceedings. Appointment of persons for cooperation. SA representatives may directly communicate with foreign authorities. S26. April 29, 2010. Coordination of SA and foreign insolvency proceedings. If foreign main proceedings are recognized, SA insolvency proceedings may only apply to SA assets. S28-1. Concurrent proceedings must be coordinated under S25 to 27, S29. If multiple foreign proceedings exist, SA courts must ensure proper coordination. S30. April 29, 2011. Other effects: insolvency presumption and hodgepodge rule. Recognition of foreign main proceedings creates a rebuttable presumption of insolvency in South Africa. S31. Hodgepodge rule. Creditors paid in foreign insolvency cannot claim more than others in SA insolvency. Ensures equal treatment of creditors across jurisdictions. This summary covers the Cross-Border Insolvency Act comprehensively, highlighting key legislation and case law for reference.